The Wyoming Eviction Notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Wyoming. Non-payment and non-compliance notice. In the state of Wyoming, landlords can terminate the lease for any violation of its terms by the tenant by sending them a 3-day notice of termination. It can be non-payment of rent, causing health or safety issues, damaging the rental property, nuisance, etc. The law does not require the landlord to let the tenant correct the issue. However, the landlord can choose to write it out in the notice. The tenant who pays all past due rent along with associated fees before the eviction hearing takes place stops the eviction process. What if the tenant fails to comply? If the tenant fails to comply with the rules of the lease and landlord's requests, the landlord can file a complaint with the appropriate Wyoming Circuit Court. The filing fee is $55. Prior to the hearing, the tenant should get the summons and complaint by a person over 18 who is not participating in the eviction process 3 to 12 days prior to the hearing. An answer from the tenant is not a formal requirement in the state of Wyoming. The tenant's failure to appear for the hearing might result in a judgment in favor of the landlord by default. If the landlord wins the case, the court will issue the writ of restitution. After the local sheriff receives the order, the tenant has no more than 2 days to move out before they are forcibly removed from the rental unit.